English. So, więc teraz dzień dobry. W drugim dniu konferencji rozpoczynamy panel międzynarodowy w języku angielskim i już z nami są zarówno paneliści na sali, jak i paneliści, którzy się łączą z nami poprzez aplikację Zoom. Tak samo witamy bardzo serdecznie zarówno osoby zgromadzone na sali, jak i osoby oglądające nas na YouTube Adwokatury Polskiej. Dzisiejszy poranny panel to panel zatytułowany Pełnomocnik w mediacji w różnych systemach prawnych. Będzie on w całości w języku angielskim, dlatego ja już się przestawiam również na język angielski, tak żeby wszyscy nasi paneliści mogli nas zrozumieć. Once more, good morning everyone. Thank you very much for joining us. And I'm very pleased to be the moderator of the panel Legal Representative in Mediation in Various Jurisdictions. The panel will be entirely in English, and due to technical restraints, whenever you'll be speaking, I'll be muted, which is even better for you probably. And without further ado, I'll introduce our first panelist, Tat Lin from Singapore. He's an IMI certified mediation advocate and an IMI certified mediator. He has been in legal practice for over 30 years and has been involved in the mediation of a wide range of disputes, including energy, construction, commercial and social and environmental disputes. He is a fellow of the Chartered Institute of Arbitrators, a distinguished fellow of the International Academy of Mediators, and a Weinstein Jams International Fellow. He serves in the Mediation Committee Advisory Board of the IBA, the Independent Advisory Committee of IMI, as a co-chair of the Law Society of Singapore Mediation Committee. He's also a chair of Society of Mediation Professionals in Singapore and as a board member of Singapore Mediation Center and International Academy of Mediators. He teaches negotiations and mediation for institutions and universities based in various parts of the world. Thank you very much, Tad. Please share your own screen and we can start with your presentation. Thank you.
So much, Cesare. Lovely to be here and good morning to everyone there. Well, let me start by saying it's afternoon here. So I should also say good afternoon to everyone. I'm going to present very quickly maybe touch on the issue of advocacy of mediation, effective mediation advocacy. Given the time constraints that I have to develop this theme, what I'm going to do is to use my own experience, both as counsel as well as a mediator, and touch on some of the challenges that we face as practitioners in Singapore when going into a mediation process. And to do that, I'm going to rely on illustration of a case at least that I've done, among other things, and also to rely on some of the frameworks of law and guidelines, practice directions, practice conduct rules that we have in Singapore. But let me just start with an illustration of how practice is like here, and I suspect it's not very different from what you have in Poland and maybe generally in across the world as well. But in every representation, you start with generally a counsel, a lawyer who comes on board to act for a client, not different here. And then, you know, in a dispute that arises, that is two parties, of course, you have, in represented situations, you have the other side and then the lawyer representing the client on the other side. In this situation, of course, we are introducing a neutral in the form of a mediator. And what I would like to do and just develop is to ask the question, in respect of all the interactions and the communication between the lawyer A and the various parties that are involved in the mediation process, what would that look like when we segue and think about what mediation advocacy is and what it means to have effective mediation advocacy? Does that even exist? Does it matter even to the mediation process or the mediator? I want to sort of roll this out by way of, say, a case that starts before mediation. So let's think about any case. that starts before parties go into mediation, before maybe even contemplate mediation. I'm going to take the example of a family case, but a lot of the themes in this case and examples of the exchanges of letters and the contents of the letters I'm going to show you, I think are applicable also in commercial disputes, right? Because litigation lawyers by and large are trained to be positional. They are trained to posture, they are trained to claim value. And for the purpose of the next couple of slides, you will see a case unfolds where there are two sets of lawyers representing a client in a family dispute where you see the exchanges of letters. So this is a situation that starts with lawyer A writing to lawyer B, and then you see some responses, right? So these are open correspondence, meaning they're not without prejudice letters, but you will see that in the language of a lawyer that writes to the other side, language like this is used. And I quote it verbatim because this is to give you a flavor of what sort of correspondence you can expect sometimes when you're practicing in the Singapore/common law world, what sort of letters you might receive in a very adversarial process before you even get to mediation. So words like clients deny your client's insinuation, your office did not extend to us courtesy, we ask that you cease and desist from making such accusatory allegations. And then as the correspondence develops and the case develops, you see that the correspondence become more and more intense in terms of the language used. Like, for example, the second paragraph, we fail to understand the meaning of this paragraph, meaning the paragraph that's written by the other counsel. And in any event, the reason why our client needs your client to do certain things was evidenced in the email. So you see that that response is a pushback, a very clear pushback. But what I wanted to do was to share with you that to the writer, maybe the writer thinks, it's all right because I'm a lawyer, I'm writing this to put forward my client's best position, the strongest position. But I invite you to consider the perspective of the reader, not just the reader from the lawyers who's receiving the letter, but the lawyers who's receiving the letter eventually will, of course, have to forward this letter to his or her client. And I think what I imagine a client, when reading this, would immediately feel that sense of discomfort because of the tone within the context of an open correspondence. So you see that the correspondence itself is filled with language that is very polarizing, scorn, I thought, contempt, even disparagement, right? And could you not write a letter with the same effect without using those kinds of language? In mediation, of course, we say you take away the sting from the language and you put forward language which is neutral. So I've sort of taken apart the three paragraphs, and you will see that if you were to reframe the language, you would be able to say the same thing, but without having those polarizing language there. For example, the last paragraph, take away all those words and you still are able to say our client reserves his right to respond to your client's comments at the appropriate juncture. Perfectly reasonable response. Anyone reading that won't feel your blood pressure rising. But the relevance of this is, how would all this feature if subsequently your clients or both parties decide to go into mediation? Let's move a bit further down the roadmap of this particular case. So at some point in time, the parties decide that maybe mediation would be a good step. And certainly in the family disputes in Singapore, at some point in time, parties are always encouraged to go into a mediation process. So here's a case where even before considering mediation, those letters were flying. And now parties and the lawyers are considering mediation. And these are, again, actual language used in the without prejudice correspondence. You will see that it says, we are only prepared to agree to private mediation if you pay for the cost of mediation. Again, the logic of it is not, may not be clear to you, but over here in Singapore, when you look at mediation, if it's private mediation and fees have to be paid, typically both parties will pay equally. But yet you have one counsel here going beyond the norm and trying to say, well, you should pay. Does that help? And then look, the language in the without prejudice correspondence, the second paragraph. Your client is well aware that the marriage broke down as a result of your client's conduct of abandoning the family for blah, blah, blah. Again, query, does that really help? again, because you know, this correspondence now is even closer to mediation because parties are writing these on a without prejudice basis in anticipation of going into mediation. And again, I said, if you tear apart this letter, these two sentences, take away the sting, you could still end up putting forward what you want to say, but without the sting. So it brings us to the point where we ask, you know, the role of counsel at mediation and the challenges of going to mediation. At the doorstep of mediation, what sort of things should a counsel be mindful of? The language in the correspondence, even before you get there, the examples I gave you, are those language and letter writing helpful? Is it necessary to be so adversarial in all the work that you do, especially when you know that at some point parties might actually enter into a collaborative process like mediation? Well, further down the roadmap, this same case again, right? So look at this case statement. In Singapore, what we do have is when parties go into mediation, parties are invited to exchange mediation case statements. These case statements are prepared by the lawyers and they're exchanged to each other and also given to the mediator. So these are the language used, and you will see that again in a mediation case statement like this, there is a projection of blame to the other side. Of course, this case statement is written by the wife's lawyers, and you see the red parts, it seems to be putting the blame to the husband's side. Again, if you strip away the contentious language, you could still put your message across in a case statement without the polarizing language. Here's another example. Right, our client has provided overwhelming evidence in affidavits to show that family violence was committed by the husband. We do not intend to pause through the evidence at mediation. Then why raise it, right? I mean, if you are going to mediation and you feel that it's a good forum to help resolve disputes, why would counsel put forward language like this? Again, these are things which I don't know would help the mediation process, but certainly something for you participants, just think about this. Is this the way that you would write when you are counsel acting for one party or the other party? Because the litigation mindset often causes us to react a certain way, right? That it's a tit for tat response. We want to, you know, claim the highest in every case that we go, and sometimes that leads us to write like this. But it does lead us to this point where often, by the time you arrive at mediation, parties look very frazzled. They have a huge distrust of each other. There's a lot of unhappiness because principally I think the work, I would say, that's sometimes done by the advocates before you reach there. And so it begs the question that when you get into mediation with all that's been done so far, what can a lawyer A do if lawyer A has been responsible for those kinds of language in the pre-mediation correspondence? One of the things which we have here is the professional conduct rules that binds lawyers. And in one of the rules that relates to family practice, you will see that this rule requires lawyers who's representing a client to be conscious of the desirability of reducing conflict. And yet, you know, despite this, we still have in Singapore a very adversarial sense by lawyers practicing in family law. I think the landscape is changing, but you will see that it takes some time for this to happen. And then also another practice conduct rules that say in family proceedings especially, lawyers must be constructive and conciliatory in the conduct of those proceedings from the time the proceedings are contemplated until the resolution. Again, think about this rule and think about whether you know the language of the correspondence which I have shown you earlier, does it tie in with this practice conduct rules? The dilemma, I think, is one that's been played out, you know, ever since mediation was introduced to Singapore landscape. The question of what makes for good mediation advocacy. And I'm just going to list out a couple of things that are research information to just ask you to think about this. How does this data help us when we think about what is good, considered, effective mediation advocacy? This research, I think, is known to a lot of people. The idea that small talk can actually generate a nice relationship before you start negotiating, and that people who actually do that, negotiators who do that, seem to have better success at the end of the day than those who don't. But, you know, query when you apply this research principle to mediation advocacy, how does it apply to the lawyer? Is the lawyer supposed to be doing this small talk with the other lawyer or with the client on the other side? Here's another research base, right, done by Dwight Golan and N.J. Forberg, that, you know, when lawyers, especially litigation lawyers, go into a mediation context, often their mindset is thinking about value claiming, less so value creating. But imagine that if both sets of lawyers are coming and they are both doing value claiming and nobody's interested in doing value creation, you can see at the bottom right-hand corner, that quadrant, the outcome tends to be fairly mediocre. So here are some final thoughts, because in all of 15 minutes, all I want to do is introduce some thoughts and some questions that we can think about when we go into a discussion forum. One of our professional conduct rules talk about these, which I mentioned earlier. But again, the IMI competency criteria also mentions and reminds mediation advocates that if you treat the mediation process like a courtroom process, then mediation can fail. Robert Angiel said it very nicely when he says you cannot go and represent a client at mediation without understanding what it is and what's a useful way to represent your client, to put forward mediation advocacy, which is very different from litigation, trial, or appellate advocacy. Many people seem to realize this, even litigators, based on Hal Abrahamson's research, but yet you find this issue pervading in all of the work we do. So I'll just end with these two slides and food for thought. Can mediation succeed without thoughtful mediation advocacy? Can you, despite the lawyers in the room not doing their best as mediation advocates or not knowing what to do as mediation advocates, can you still get a good outcome? Can a mediator be effective without good mediation advocates in front of him? That's the question. Now I'll leave you with this last question. Would some parties in mediation actually be better off without legal representation? Sad question to ask, but sometimes maybe worth asking. So on that note, I end, and thank you for giving me the opportunity to share these thoughts. Thanks, Cesare.
Just say a brief hello to the audience that's watching us online today. And real brief, I would just like to extend the warmest and kindest and most heartfelt thank you to the organizing committee of bringing us together, the community of lawyers, to promote peaceful means of dispute resolution. Your hard work is admired and appreciated. Thank you so much. And ladies and gentlemen, today I would like to indulge you in the concept of compassionate lawyering in a mediation context. I would like to offer a sincere thank you for the generous support of the Kościuszko Foundation for giving me the opportunity to research personal injury, compassion, and mediation. And like I said, or like Cesare says, we're on a time crunch today, so I will try to make my presentation as brief as possible.
Please do.
Yeah. So just to get started, let's jump right into it. No one really cares how much you know until they know how much you care. This quote goes out to Theodore Roosevelt. The man received a Nobel Peace Prize, so after all, I believe that his peacemaking efforts and his quotes do speak volumes. What does that actually mean? How does that quote translate into the relationship that lawyers and clients share? And if someone is to question the legitimacy of the empirical inquiry of compassion and empathy in the realm of personal injury and generally in the realm of law, well, ladies and gentlemen, I am sorry, but it doesn't matter what the lawyers think. It really doesn't. And it has been proven by the Institute for the Advancement of the American Legal System at the University of Denver. They concluded two excellent studies, one of them being what does it mean to think like a lawyer and what does it mean to think like a client. And ladies and gentlemen, the clients think that our demeanor actually matters. And if you can see on the right side, you can see that clients actually value empathy and compassion. So it's sufficient to say that we do have to include this premise into our practice. But like I said, my research has been done in the state of Michigan, and although some of the conclusions that I draw are Michigan specific, I would like to encourage you to take a broader view and to take a perspective. Perhaps some of the things that I will talk about will can be universally applied to whichever jurisdiction. So what is compassionate lawyering and good settlement results? What those two things have in common. So as much as I would like to reinvent the wheel of attorney-client communication, well, unfortunately, this is not the presentation for it. So because I would like to tell you that we as human beings, we are hardwired to receive and give compassion. And we're hardwired to receive and give empathy and compassion at a zero cost. So then, ladies and gentlemen, the question becomes, why not use it? And because we are hardwired to give and receive empathy, the three premises of a compassionate lawyer, especially in a personal injury context, become, first, we need to establish trust and rapport. And since we're hardwired to do so through the means of compassion and empathy, the ground rules or the groundwork has been already done. So establishing trust and rapport with the client is crucial. So what it means to me, what a compassionate lawyer is. First, he establishes trust and rapport with the client. Second, he stays in touch with the client. What does that mean? He maintains a steady channel of communication. And I wouldn't be telling you this, ladies and gentlemen, if I wouldn't hear about cases where a plaintiff has lost his entire family in a catastrophic injury. There's millions and millions of dollars in insurance coverage, and the attorney does not call and check on the client. He doesn't ask him, how is he doing? How are his feelings? Is there anything that, that can be done to alleviate his pain? And with that, and also I would like to draw your attention, all of those statements that appear on the slide, all of them are true. These statements have been delivered by both plaintiff and defense counsel. So unfortunately, the last quote, it's all about the money. Well, yes, absolutely. If we think about personal injury, which are tortious acts, and the nature and the compensatory nature of the tort system actually determines the monetary outcomes, right? So if we have the monetary outcomes, why do we even bring up the intangible or non-monetary interests? And I would like to caution you that when I was researching compassion and empathy, I couldn't ask the lawyers, sir, are you compassionate? Madam, do you have empathy? Because it's a bias minefield. Instead, I decided to inquire about the intangible and non-monetary interests and how those translate into better settlement results. And let me tell you, the attorneys delivered. It is not to say, ladies and gentlemen, that having compassion is something, okay, we're hardwired to do so. But it is important, and meaning that having compassion and empathy does not mean that you have to tell your clients, I feel your pain, or I understand where you're coming from. Because more often than not, the majority of personal injury cases are catastrophic injuries. They're auto vehicle accidents. They're medical malpractice cases, wrongful deaths. So unless you have experienced that, I don't think it's legitimate for you to tell the client, I feel your pain, or I understand where you're coming from. Instead, at the outset of your relationship with the client, I encourage you to ask meaningful and thoughtful questions that are actually goal-oriented, but are transparent enough for the client to understand that you also understand where that person is coming from. And those questions could be at the outset. What are the most important goals for you in this case? And why are those goals important for you? In the alternative, you can also inquire, what are the other side's important goals and interests, and inquire about those. And finally, what are the issues that you would like to resolve? And I would like to tell you that you can be a zealous advocate for your client and have compassion. You can be assertive and have compassion. You can draw a clear line between the relationship that you have with your client and be compassionate. And of course, clients, more often than not, they come to you at a very vulnerable state. And vulnerability is often perceived as liability. And if we think that collectively as a profession, we don't take care of the clients, well, that is to the detriment of us all. Because those clients, if they're not being taken care of, if they don't feel that they've been heard, that they have been listened to, eventually those same clients will exploit not only the healthcare system, not only, so what I mean by that is the taxpayers' money, and they will also exploit the justice system. So that is to the detriment of us all. So personal injury, like I said, please consider motor vehicle accidents, wrongful deaths, product liability, miscellaneous cases. Of course, medical malpractice is not personal injury per se, but it does carry that heavy load of intangible and non-monetary interests. And some of the challenges for a compassionate response, especially for a personal injury attorney. So you have to consider this dynamic that goes on between clients and attorneys. So first of all, God forbid that those would be repeat clients. So more often than not, personal injury clients are not repeat clients. And like I said, God forbid, because I would assume that nobody would like someone, coming after a catastrophic injury to be, a repeat client. But the law doesn't really have any mystery to it. So although the clients may not be repeat clients, the claims are. So it gives you a chance, it opens up a window of opportunity for us to implement certain strategies and techniques that will help you address those non-monetary and intangible concerns a little bit better. And if you would consider, and I wonder if this is true for your practice as well, a standard personal injury attorney has a heavy caseload, and by heavy I mean he runs around 100 files. So of course his interest is to move the file and to resolve the case. And you would probably, I hope that some of you wonder, how long does it take to resolve a personal injury case? From the intake portion, it takes roughly around 4 years. So if you will consider 4 years of the client being in the abyss, and let me tell you right off the bat, the majority of the personal injury cases do settle. But this all has to do with the ADR model that is in the state of Michigan. But if you will consider 4 years in the abyss, clients often develop PTSD from litigation. They often suffer from compensation neurosis, which is a condition that makes the clients emphasize their conditions to gain litigation advantage. Alternatively, they can also suffer from numbness, and you have to take care of that client. So these are some of the challenges. And we have to factor, and I would like you to take a minute to read this quote. And Michigan is a state that doesn't have a continuing legal education requirement, which is, I believe, quite unfortunate. And counsel still says that those biases, racial, sex biases, they all play a role in the assessment of their cases. So being aware of our own biases is also critical to develop and to create better outcomes for the clients. And when this was a statement made by the defense counsel, and he said that he may put a higher value on a case if it's a an older white lady crying versus a young black man crying. And if you will consider the legitimacy of the personal injury claims that are being filed, and this is a very broad spectrum, ladies and gentlemen, and I wish I had more time, but if you would consider this a triage process, I don't have much time. So the triage, the compassion and empathy process is a triage process. So we have the plaintiffs, the defense, and the insurance company. And the common adage for the insurance companies is to delay, deny, and defend. But if you would consider that 80 to 20% of the legitimacy rate of all insurance claims that are being filed, meaning that only 20% of those claims are legitimate, well, maybe in the alternative, you won't think about the bad, big insurance companies, okay? So moving on, let's jump right into Michigan mediation. So parties are offered multiple instances to settle cases in Michigan. So whether it be through case evaluation, whether it be through facilitation mediation, but what is characteristic to the resolution of personal injury cases are case evaluation panels, which actually they mirror arbitration more than they do mediation. And that is why a mediator in a personal injury case has more often than not 30 up to 40 years of experience and has that subject matter expertise. So that is actually the evaluative model that mediators use. And that's why the majority of the cases do get resolved. Last 2 minutes. How do we put a value on a personal injury case? Cesare, what's a broken arm worth? It depends whether it's your arm or mine. So this is how clients see their hurt. So I've been hurt and my life has been changed forever. But the attorneys are willing to put a higher value on a case when they see an emotional response from a client. So like I said, it is believed that attorneys actually do use empathy and compassion intuitively. And some attorneys consider it to be unethical, not to consider those emotions and intangible interests. What are the intangibles? The poster child for all intangibles: apologies, establishing a trust fund, a scholarship, an opportunity to express feelings and emotions. And although those needs and wants are non-monetary per se, they can also substantially impede the resolution of a case. So just if you think about medical malpractice and, you know, apologies being the unicorn that doesn't really appear much in settlement negotiations, well, in medical malpractice, the University of Michigan is actually the champion of introducing apologies in a medical malpractice setting. So if you think that apologies are useless, think again. Lessons: a very short case. An auto vehicle accident when a 4-year-old child darted on the street. The insurance company offered right off the bat the entirety of the policy, but the mother of the child was still pushing for the defendant to pay out of pocket. And what does that mean? That she wanted that intangible, whatever interest that she had, she wanted that retribution. And the underlying issue of the case, as the attorney noted, was the non-monetary goal of the mother to pay out of pocket. And the case resolved. In its simplicity, it was genius. So the defendant actually offered to pay a substantial amount of money for the cause of whatever the cause that the parents were interested in. I believe it was a scholarship. So I hope to be wrapping this up, and I wonder, would you, and I wonder if you think that you're in the profession of caring. I don't know. I think we are in the profession of caring to a certain extent, but the attorneys say, one of the defense attorneys said, "No, I'm heartless," and that's okay too. So let's not forget, ladies and gentlemen. And this is, like I said, I'm on a time crunch, and I wanted to make this very brief. But I want you to remember that some of the cases that the catastrophic injuries resulted in settlements because the plaintiffs, the mediators were open and honest, were able to ask those tough questions. But what is most important, and this is what I would like to leave you with, is to have self-compassion. Because if we're not self-compassionate, how on earth are we going to be compassionate towards our clients? I respect your time, and I really respect your patience. Thank you so much for having your attention even for this brief moment. Thank you so much.
Wow, thank you very much, Maria. Thank you for your wonderful presentation. And now we're going to Italy, and we're going to listen to Lino Orico from Milan, who is an attorney at law and at the same time a mediator. He has been an expert at the ICC mediation competition for many, many years, and is also a very compassionate mediation advocate, and also is a member of the UIA, who is the secretary of the Equal Opportunities Committee and the member of the Commission for International Relations at the Council of the Milan Bar. Lino, I'm leaving the floor to you. Please share your own screen, and I'm muting myself right now. Thank you.
Thank you very much, Cesare, and thank you very much to the organizing committee. I share my screen. Here it is. Okay. So my speech will be about, first of all, a very short overview of how mandatory mediation works in Italy, what it is, which are the numbers, and what are the effects on the process. After that, I'll give a perspective from the point of view of the lawyer, of course. So let's start. First of all, some numbers. As you can see, they're huge numbers because mediation is effective here in Italy as mandatory since more than 10 years. And last year we had 237,000 mediations. That, if you consider that it was during COVID-19, they are very huge numbers. I also have to say that during that period, the law was amended with the possibility of having mediation video conference, and that worked very well. All these numbers, you can find that on the internet website of the Ministry of Justice. So, a short overview on what are the matters in dispute that as a prerequisite for the admissibility before a court. So there are condominium, real estate, partition, inheritance, family covenants, tenancy, comodatum, business lease, medical malpractice damages, libel, banking, insurance, financial contracts. As you can see, you cannot find, for instance, labor law and family law. And that's a pity because there are some matters that would be in a very efficient way solved before a mediator. Very shortly, how does it work, the mediation procedure? Because the European rule was interpreted in many ways in Europe. So I know it's different in Greece or in Poland, for instance. So in Italy, a first meeting takes place and the mediator explains all the parties what is mediation, what is its purpose, how much does it cost, and all this information. So at the end of this first conversation with a mediator, the parties are requested to declare whether they wish to start mediation or not. If they say yes, mediation proceeding starts, and so the parties will have meetings with the mediator and the lawyers. On the other hand, if one or both parties say no, they don't want to start a mediation, there will be a certification of a failure of the mediation attempt, and the parties will be free to file a lawsuit. Of course, the fact that there is a law that is regulating mandatory mediation has some effects. First of all, the law impacted the admissibility of the claim. And of course, as that said very well, specific skills are required to the lawyers. And thanks to the law, the agreement, if the parties get into an agreement, is enforceable. And of course, there is an influence of the interpretation of the law from the courts. There are many decisions, but I would like only to show you 2 years ago Supreme Court decision that is very explains very well what mediation is and what is intended to be. The success of the mediation activity is placed in the direct contact between the parties and the professional mediator. So the direct contact, that is something that in a process before a court does not exist. Who can, thanks to the direct and informal dialogue with them, help them to reconstruct their previous relationships and help them find a solution that, beyond the solutions in law of the eventual controversy, can allow them to avoid the escalation of the conflictuality and to settle amicably a potentially opposing proceeding with mutual satisfaction, favoring at the same time the continuation of the commercial relationships. This decision is very important because there's also something to say about the lawyers. And the same decision says that the presence of the lawyer was not originally even provided by the law. It was in fact introduced on 2013. And it can be observed that the 2013 amendment, which introduces the necessary presence of the lawyer, a lawyer expert in procedural techniques who represents the part in the process, a lawyer skilled in negotiation techniques who advises the client in the mediation procedure, also marks the gradual emerging of a new professional figure with a partly different role and which requires the acquisition of further relational and human skills, including the ability to understand the interests of the parties beyond the legal claims advanced. And that's very important because also the Supreme Court is advising lawyers that our profession, as we intended to be before, has had a very big change. And good news, our new Minister of Justice, Marta Cartabia, in her guidelines, says the mediation must be effective by amendments aimed to extend its mandatory application, namely in those subject matters where it is more successful, and namely labor law and family law, to have further economic and fiscal incentives, and increase mediation delegated by the judge during the process. So I stop sharing. Okay. So, but let's get to the main point of the speech. The role of lawyers in mediation. Of course, as that very well said, there is a new role of the lawyer before a mediation. First of all, there are some duties, and the first duty is information about mediation. Our legislative decree compels information by the lawyer to the client about mediation process, that is tax relief, admissibility of a claim, and all this information. But this is also an opportunity to explain to the client what mediation is and why it could be a very good solution in order to solve a conflict in a fast and profitable way. This is still true because at the beginning of the application of the law, I think many lawyers didn't know exactly what it was, and so they could not explain to their clients what they were going to do. And now I can say that it's more spread, and lawyers are much more careful explaining what mediation, and not only explaining what is compelled by the law, but also giving further information. And let's come to mediation. It's very important to have examination, a 360-degree view of the case. I think that to get a very deep examination of the case with the client is always very important, of course, in any case. But in mediation, it is even more important. Of course, in a process before the court, we are focused on facts and documents strictly related to the case. It is forbidden, for instance, to introduce new documents or to argue about arguments that are not contained in the case. In mediation, client interview, I think it's crucial to understand which are the needs and problems that we don't use to consider before a court. But in mediation, we are also negotiators, and we don't have to forget it. And the more information we have, the better we can have control of the mediation in order to achieve a best result for our client. That is why an open interview with the client is the basis of a mediation. And of course, perfect handling of the mediation process. When we are studying law, when we studied law, we still studying law, of course. We were prepared to lawsuits, and it is easy to understand why many lawyers prefer the tranquility of a process before the court. Of course, tranquility in quotes. On the other hand, mediation is an informal procedure, and we don't have a judge who says who's right and who's wrong. And our client is free to say anything comes to his mind, and sometimes he says what we advise him not to say. Of course, we are lawyers, and we are supposed to know the legal aspects of the case. We can read it in lawyers' code of conduct, as also said. But on the basis of the same code of conduct, we have a specific duty to know mediation process. And of course, its effects on the process before the court as an admissibility prerequisite to it. And if we perfectly handle the mediation process, we are not afraid of what our client is going to say during a mediation session. We probably already know what he's going to say. And we are prepared to it because we already discussed it with our client before mediation start. And of course, about the mediator. That empathetic woman or man who is doing her or his best to drive conversation between parties and lawyers, and sometimes to sedate excessive aggressive reaction of the parties and sometimes of the lawyers. For the lawyer assisting the client in mediation, the mediator is a very powerful instrument, and the lawyer has to know how to use it. I'm really surprised when I ask for a caucus during a mediation session and colleagues look astonished, wondering what it is and what it's for. And moreover, a mediation session is also a negotiation, don't forget it. And we have to know how to manage it at its best. That means that we also have to be skilled negotiators, and this sometimes is something completely different compared to our ordinary activity as lawyer assisting a party in process before the court. At the end of the mediation process, if a party is getting an agreement, our skills as legal advisors are important again, of course. And drafting the agreement is something that lawyers can do better than other professionals. And I think that it is why I can suppose that the choice of Italian legislator was to consider legal assistance in mediation mandatory. And of course, because of the relation of the mediation with the process too. I will give you some closing remarks. Mediation has to be considered a revolution for lawyers. When Legislative Decree 28 was published in 2010, lawyers were very reluctant to accept this new way to manage a conflict out of the court. And not to say that they were adverse. I still remember the Italian lawyers got on strike against mandatory mediation law in 2010, 2011. But now a larger part of our colleagues is in favor of mediation, and that is thanks to mediators, of course, but also because clients are very happy to have a favorable and fast solution to a conflict. But it is why my opinion is that we have to consider ourselves not only as litigators, but as problem solvers. This is what our clients are asking for, I think. Thank you, Cesar.
Thank you very much. And now directly from Italy, we're going to Greece. I'm sorry, I just need to grab my computer. Elena Kotsaki. Dr. Elena Kotsaki has a PhD in law. Elena is a lawyer, mediator, and mediators trainer in the Bar of Athens, and also an adjunct professor at Alba Graduate Business School of the American College of Greece in negotiations, mediation, and conflict management. She's also a member of the International Advisory Board of the Global Mediation Panel, Office of the Ombudsman of the United Nations Funds and Programs, mediation expert at the Council of Europe, European Commission for the Efficiency of Justice. And last but not least, Elena is president-elect of the International Academy of Dispute Resolution. Thank you very much for joining us, Elena, today. And the floor is yours. And I'm just muting myself right now. Thank you.
Thank you so much. Thank you for your kind invitation. Congratulations to everyone for hosting this. It's my first hybrid conference, I must admit. I've been trying, in our school, we're trying to consider how to do hybrid classes. So thank you so much for giving me this opportunity to participate in this wonderful initiative. I'm gonna put my PowerPoint on the screen right now. Congratulations to the previous speakers for their insights and inputs. Let me know if this shows properly or if I need to switch screens. Does it show on full screen? Okay, excellent. Thank you so much. So I'm here to contribute with the latest developments in Greece. And basically the reason for doing so is to see whether we can learn a few things of how mediation really developed in a country that had no such word. I know we have given the world with many wonderful Greek words, especially in the Greek vocabulary, but guess what? We didn't have a word for mediation, not before the European directive, because we didn't have it as an institutionalized way of resolving disputes before 2010. So it was only in 2010, and I'm not going to share the Greek word with you because I'm sure you will get lost in all the syllabi inside it. But the thing is that we only got acquainted with the institution of mediation in 2010, when we had to implement the EU directive on mediation on civil and commercial cross-border disputes into our legal system. And we did that through a law back in 2010, which worked for 8 years, which was in place for 8 years, but unfortunately it did produce very, very poor statistics in terms of how it affected the service, service of justice over the years. Unfortunately, some numbers, these are not fully updated because of COVID, but the EU scoreboard listed Greece on the, on the countries that were ranked very last in the delivery of court decisions. And we have an average of 1,580 days for a case to be resolved in court. The number of pending cases in courts of a first instance is huge. The number of decisions issued per year is also very low. The total number of judges is enough for some people, but then again, over the years that we had mediation, at least in the first 5 years where we were able to gather some statistics, we only had, I would call, a handful of cases mediated. A handful of cases mediated and mostly used, taking advantage of the institution of judicial mediation and not so much by private mediation. So even if we had to measure the success of the law after 2010 regarding what the EU were expecting from Greece, and that was expecting actually from all of the European countries, is to create a balanced relationship between the cases resolved in court and the cases resolved through other means such as mediation. And that led of course, with many other background stories, Greece being in a financial crisis, being pushed for reforms. But that basically, the very low numbers and the fact that we had to reform justice system as well, led to the first law in 2018 that introduces mandatory mediation. And following up on Lino's very nice presentation, I'm very happy to say that we copy and paste it in a way, or at least we try to look at the most successful mediation models, especially around the world, but especially in our neighboring countries. And it was evident that the Italian model was the one that would get us out of these very low numbers and very low use and awareness of mediation in Greece. Unfortunately, at that time, in January 2018, and because during the legislative process, lawyers got super scared of what is going to happen to them in the days following, we faced a very, very fierce reaction. And what was interesting back at the time, I was a member of the law drafting committee, so I could share thousands of stories about what happened and how we came to this draft. It was interesting that we had fierce reaction also by judges. So it appeared that we had a cultural issue to also address when we're introducing mandatory mediation model in Greece. And of course, some of the criticism was, of course, justified, but whatever the case was, it led to the suspension of the law that lasted for almost 2 years. So under the pressure of all the reaction, the Ministry of Justice and the political risks involved. We had elections at the time, so there's a lot of cultural background and historical background that led to another law, came in force late November in 2019, which is an amendment, is actually, we shaped it up to satisfy the stakeholders' needs. It did become effective in January 15th of 2020, only for family disputes, and it was to become effective from a huge range of other disputes, namely all of them falling within what we call the normal proceedings, mostly commercial disputes, inheritance, torts, everything that has a value above 30,000 euros. But if you look carefully at the dates, you will realize that the god of mediation was not on our side, because as soon as we started trying to implement this new law and see how it would work, we had to go into the lockdown. And that, that led to new dates, a new postponement of the enforcement of the law to July 1st of 2020. We have been able still, but very, and I will share some statistics in a minute, we have been able still to just taste how this works. What does the Greek mediation model on mandatory mediation provides? First of all, it provides an obligation of the lawyers to inform their clients in writing. I will stick to that because I want to place the importance of this by the judges later on. The law also provides that the party who wants to initiate proceedings or started proceedings, that this party needs to contact a mediator and set up a first mediation meeting. The law provides for the parties to attend in person a first mandatory mediation meeting, except when in cases when this is not possible, the use of electronic means is allowed. And this has been the case during the COVID challenge. The appointment of a mediator is one that is listed in the public registry. I will share with you later on how we manage this. The first mediation meeting takes place in 20 days since the notification. And here comes the role of the lawyers. Parties are obliged to be assisted by lawyers, except in a few only cases. What does mandatory mediation means? It means that the party who wishes to file a case in the court, if he fails to initiate such a meeting, then the judge will declare the inadmissibility of the hearing of the case in the court, not the inadmissibility of the filing, as we as the drafting committee have suggested, and this already creates problems, but the inadmissibility of the hearing of the case. What comes as a second step is that if the whole process is initiated by the mediator and the parties have been notified of the meeting, and if they don't show up, then it is upon the court's discretion to impose a fine on them that ranges from 100 to 500 euros, of course, based on the judge's assessment evaluation for the reasons of non-attendance. What the new law also provided is that we have a new code of conduct for mediators, that there is a set fee for mediation that refers to the first mediation meeting. And unfortunately, it's only set to 50 euros unless otherwise agreed. But then again, we do have this window open for otherwise agreed. We have a very well elaborated system of accrediting mediators, and I will show in my next slide what I mean by that. A supervising body that sits at the Ministry of Justice, which overlooks about the application of the law that is called the Central Mediation Committee, the public registry of mediators, and of course the law also talks about statistics, because this is exactly how we're going to measure the success. I was referring earlier about how we appoint mediators. I'm sorry, it's only available in Greek, but I am sharing with you a screenshot of a website that is dedicated, is hosted by the Greek Ministry of Justice, and is dedicated to the handling of mediation cases. What happens here is that people can click on, I want a mediator. And when they do that, of course, here there is a login section for all mediators. All of us, which are listed in the public registry, enter this website and can find out about the cases we are assigned for mandatory first meetings through the system, through our IRS credentials. And the way a person, a citizen, can actually ask for the appointment of a mediator is run through an online platform that is hosted here, where the citizen can enter with his IRS credentials. And what he gives, the person gives, is the data of his own personal data, the data of the person to whom he wants to file a lawsuit, and a very brief description of the case. And the system appoints a mediator on a rotation based on the place of the relevant court that would have judged the case if this case was to go to the court. And my experience here is that I think it's kind of a novelty. I haven't seen that in other countries, correct me if I'm wrong, but this is quite an objective way of appointing mediators. I know my time is limited, so I will try to share as more info about how we work here. We don't have published statistics. We can blame it on COVID. We can also blame it on the slow Greek system always providing statistics. In any case, we do experience, even in this short limited period of time, and despite the fact that we all had to face restrictions, we did see a very impressive rise in the number of cases after the application of the new law. What was also interesting, and we had like a couple of months ago, the first cases on law, and this links to our discussion today, we had the first judges declaring the inadmissibility of the hearing of the case when they received a paper in writing confirming that the lawyer has informed his client about mediation. But listen to that. Because this document was signed after the date of the filing of the lawsuit, the judge said it was useless. This is a very important change in the way judges are approaching mediation. And the reasoning, it's really, I got goosebumps when I saw that. I said, oh, okay, we have judges, we understand mediation says, if this is to happen, it has to happen before you file the lawsuit. So they declare the inadmissibility of the hearing of the case, and now they're kind of punishing lawyers for not doing this properly. Few other reforms of mediation, fresh from the press. We do have a new law on family mediation. It's a huge reform. It was only voted in May, last month. Here, what is another novelty is that we're now creating a special registry for family mediators. And we are still waiting for the relevant decision of the Ministry of Justice to define the specifications of who can be members of the specific register, because the novelty here is that the judge can order mediation and pick up one of these mediators when parties refuse to do it properly in their first mediation meeting. We have, as of June 1st, like a couple of days ago, and actually only yesterday, I concluded a training on mediators, an advanced training on mediators on how to resolve financial disputes. So we have also a new insolvency law. Everything is run through an online platform. It's about the restructuring of private debt. You know, maybe you don't, but Greece has a very high number, some billions of private debt that needs to be sorted very quickly. So we introduced mediation also there. And there will be another registry of mediators trained on financial disputes. Coming up, mediation in another law as a way to resolve disputes regarding data and their registry in the National Land Register. Why I'm trying to demonstrate all this is that we're moving forward. And we're moving forward in introducing mediation in all sorts of in wherever the government sees fit that mediation can provide solutions. Here we have in ADR Point, where I provide my services, we have also created an application with the funding of the European Union. We have an app freely downloadable on everybody's phone through the EU funding, where everything can be resolved online through our mobile phones. But of course, there's challenges. And one of the biggest challenges has to do with the parties' representation in mediation. Technology awareness, adaptation to the local needs, costs related to this, of course, the quality of mediators and the ability to collect the right statistics. I will quote something from a very esteemed judge who is a high court judge in Greece and had to rule on mediation. It's not a panacea, and I love using this word, but it is definitely not also an anathema. It's not a curse. It's not something we should avoid. And by using these two Greek words, I would like to thank you once again for your attention. And I'm more than happy to stay and have any questions you might have regarding our progress here. Thank you very much again.
Thank you very much, Elena, and thank you for your insights from Greece and from the Greek law. And because we're really running almost out of time, I'm turning now to Blanka Julita-Stefańska, and we'll come back to Poland, this time to Warsaw. Blanka graduated from University of Granada and the University of Warsaw, holds a PhD granted by the University of Warsaw, and is a qualified lawyer registered both in Lawyers' Chamber in Madrid and in Warsaw. She is also a sworn translator of Spanish language, assistant professor at Łazarski University, and last but not least, author of numerous publications regarding Polish and Spanish criminal law. Thank you very much. The floor is yours. The presentation will be here in 1 second.
So let me take that opportunity to thank the organizers for the invitation. I could not believe till yesterday that it could be possible that the first conference in presence, not online. So I'm going to talk about the status, legal status of mediator in Spain. Can I switch? Yeah? No? It works? Yeah? So the status of the mediator in Spain was regulated in 2012. It's a typo. It should be July, not June. The big mistake of the national legislator was to regulate the mediation in civil and commercial matters. And the communities, because the Spanish organization, I mean, the legal system is quite different from the Polish one. So the communities, they understood that family matters are not included in this law. That's why they understood that it's their competence. And the family, the mediator in the family law is regulated by each region. There are several laws. I mean, each community has the law on the mediator in family law matters. We are going to see the example of Andalusia. So there's a still constitutional debate if the communities did wrong or not. They abused the competences, but as for now, the family, I mean, the mediator in the family law is working on the the regional level, but the national level is the civil and commercial matters, and it's further developed in the royal decrees. So requirements: who can be a mediator in Spain? Not natural person, of course, with enjoying with full civil rights. I mean, there are some prohibition for some specific profession. Then it can be also a legal person. Legal person can be a mediator, but then it has to delegate a physical person, I mean natural person, for a mediation, which should fulfill the requirements for a natural person to be a mediator. Then the university degree, doesn't matter which kind of degree, which kind of profession or higher professional studies, and the specific course completed in the authorized institution. It entitles to be a mediator in any region of Spain, and of course, civil liability insurance, just in case. The mediation course, to be a mediator in civil and commercial matters, one or more courses. The course should cover the mediation techniques, the mediation proceedings, according to the legal principles. They should cover, the course should cover expectative third parties and mediators' liability. And of course, the special course shall provide tools to the mediator, sufficient professional knowledge, as you know, just to be a mediator, you need any kind of university degree. So it should cover legal frameworks, psychological matters, mediation ethics, communication techniques and proceedings, negotiation and solving conflicts. And of course, the course, at least by law, 35% should be practical credits. And of course, exercises, simulation, and of course, preferably the participation in real mediation. The minimal duration of such course or several courses is 100 effective teaching hours, and of course the mediator from the European Union can be a mediator in Spain if the courses is convalidated, if it fulfills the requirements of Spanish legislation. And of course, similar to what's happened in Poland with lawyers, that we should still learning, so the mediators also, once the mediator is a mediator, can complete additional courses. So it's every 5 years, at least 20 hours. It could be focused on specific field of mediation, or it could be just general skills, but it should be like long life learning. There are also mediation institutions. It's not a legal person, but it's a mediation institution. It's a public, private, Spanish or foreign institution which try to impulse the mediation. For instance, the bar offices are always included in this list, as they also facilitate the list of the mediation. They try to facilitate the access. They try to manage the mediation. They help to appoint, for instance, the mediator, and they try to preserve the transparency of such appointment. And of course, the mediation institution cannot provide the services, but they are just helping and just support the mediation. We have in Spain the royal decree from 2013. It establishes the registry. That's why I was a little bit astonished, surprised when I heard yesterday that the Polish Ministry of Justice is working on the registry, which in Spain it exists. It's not a perfect registry, but it exists since 2013. So it is a mediation and mediation institution registry. It's administrated, it's governed by Ministry of Justice. It's not a compulsory. That's why I think it's a mistake of the Spanish legislature that it's not a mandatory inscription. And every person who fulfills the requirements to be a mediator can register in any national autonomic, because we are going to see with the family law mediator that we have a local registry. So they are entitled. And it's not only the inscription is mandatory for a bankruptcy mediator, because there's different requirements to become a bankruptcy mediator. So it's a natural person, fulfills the requirements to be a normal mediator. The general mediator. Of course, additionally, it has to be a lawyer with at least 5 years experience, specialized in a bankruptcy law, or either economist, a manager or auditor, with also at least 5 years experience proven in bankruptcy law. And it can be appointed as a bankruptcy mediator, can be appointed by notary or or trade registers, or in an extrajudicial agreement of payments. So legal person also can be a bankruptcy mediator if it's acting through a physical person, natural person who fulfills the requirements of being lawyer or economist, and with experience, of course. So the registry, I just searched this to put how it's working. So I searched for a mediator in commercial matters, I think. Yeah. So we have a list. I just searched Andalusia. So we have a name, alphabetic order. Then we have the region. If it's national, international, then we have a specification. If it's a general, family matters, or international mediation, and so on. So we are going to search briefly. Then we have details. I just searched randomly. So we have a general mediation, civil mediation, commercial mediation, and the familiar mediation. And in the experience, we have a additional remark that this person is, for instance, a lawyer. So, because as we know that normally a mediator in Spain can be anyone with a university degree, but then we have this. Okay. Okay. So then we have additional, this space that we can just learn more about the mediator, about the profession. Then we have the institutions. We have, as I said, that's a registry of mediators and mediation institution, and we see that there's a lawyer bars are also in there. And if we just click on the lawyer bar, we just see the list of the mediator. Of the lawyers who are inscribed, registered in the bar, who are the mediator. 2 minutes. Statistics. As of January 2021, the pandemic times did not make it hard for the Ministry of Justice in Spain. So we have 6,819 mediator, bankruptcy mediator 119, institutions 183, Then bankruptcy civil mediators, legal person, 175. Family mediators, as I told you, they are autonomic regulation. They are more severe than the general. I just pick up the Andalusia regulation, as I'm familiar with them. So that's a restriction that it should be university degree, but restricted to law, psychology, psychopedagogy, sociology, pedagogy, social work, social education, etc. And then inscription in the registry, local registry of family mediation of Andalusia in this case. And then it has to complete postgraduate studies, and it should be 300 credits. So it's more, I mean, it's longer than for a normal mediator, which was 100 lective hours. And of course, additional courses as well, every 3 years and 60 hours in total. Areas of mediation, I'm finishing. I mean, in Spain, should finish? No? 1 minute, okay. So it's civil, commercial, family matters, of course, then the civil proceedings, they just prescribe the obligation to inform, the judge should inform the parties about the possibility of mediation. Then in criminal matters, of course, it's not expressly regulated, but it's aimed to re-educate the minor, and for adults it's to satisfy, I mean, the restorative justice, and it's always the lower penalty. And it's forbidden in cases of gender-based violence. So, I mean, in Spain, I don't know if you know, but they're very sensitive about gender violence, so they are excluded. Mediation is excluded from them. Administrative matters, we just focus, I mean, there was something yesterday about administrative matters. In Spain, it's not expressly stated, but it's not forbidden. Labor matter, 10 seconds, okay. Labor matters, it's expressly said that if you want to demand in the labor matter, it should be, it should go together with the with the statement that the mediation was not satisfied. And then thank you for your attention. And last but not least, sorry not to be politically correct, but I hope the Spain will win today.
Great. Thank you so much. I'm sorry for putting so much time pressure on everyone, but we need to be on time, especially that we're broadcasting that live. So now we're moving from Warsaw to Poznań to lawyer, psychologist, and mediator Tomasz Antoszek, PhD, who also holds a PhD, and is a head of private law department at SWPS University of Poznań. He's a business mediator by ADR Center and co-founder of House of Mediation. Tom is certified business trainer in the fields of conflict management, private law, negotiations, and mediation. He is an author of the Settlement Agreement publication and co-author of the Polish Civil Code commentary. Expert and coach at, among others, CDRC in Vienna and ICC Hong Kong, and also mediation competition in Krakow, my town. So Tom is also a co-inventor of the social movement We Love Disputes, and his research focuses on Singapore Convention, settlement agreement, mediation, substantive law, and confidentiality. And I'm switching on your presentation. Tom, the floor is yours. Thank you so much.
Afternoon, everyone. Good morning. It's not the best time for me to be the last because everyone is waiting for coffee now and to have a break. But let me tell you a very interesting story. A story of the mediation, which the lawyer's role in this mediation was really extraordinary. And I want to give you this example to show to you how much lawyers can engage not only in the process of mediation, but also in the solution. But I will reveal how did they do this later on. Before I do it, let me just tell you that it's great to be back live with people at the conference. And when I got to know that the committee, Miss President and Mr. Vice President Cesare are organizing this conference, I took the phone, I called Cesare and I said, I have to be there, Cesare, because get me out of the Zoom, out of the Meet, out of the computer. I want to be there, because I've got a very interesting story. So thank you very much for invitation, for a great evening yesterday, delicious food. There is Miss President. Yeah, thank you for delicious food, wonderful evening yesterday. Yeah, and for invitation. So let me also tell you that it's great to be back here in Białystok again. This is a picture from 1.5 years ago when we had also the conference before the pandemic. There was also a great students competition organized by Marysia, who is here, also by the university. I'm here today not with my students, but with my son. But so there are some differences, but wonderful to be there. What I'm going to tell you today about is basically, I want to tell you the story I told you, but before I do it, I want to create a kind of structure for that. So I will tell you briefly what are the researches on the role of the lawyers in mediation. Tat Lim from Singapore told about it a little bit. I would like just to point it out for you. And then based on that, you will be able to compare what has happened in the mediation I want to tell you about to the structure that I will give to you. Then I will tell you the story of the settlement, and then what was the role of the lawyers in this very settlement. And all that in 10 minutes, of course, Cesar. Yes, thank you for reminding. So first, I would like to show you a little bit how Dwight Golan looks at the role of the lawyers from the perspective of the mediation phase, because this is a very interesting how we can place the role of the lawyers in the mediation phase. So first, this is a big question, to mediate or not to mediate, okay? And the lawyers are very necessary on that phase to decide whether the case is good to follow into the litigation or to the mediation. So this is the role of the lawyers to advise. And also Tat mentioned that this is a very important process to follow. Then we've got initiation of the process of the mediation. So there are a lot of things here. You might read about it in the publications, but this is the decision on convincing the client to mediation or opponents to mediate, because your client might want the mediation, but the opponents might object to it. And sometimes this is the role of the lawyer, to contact the other lawyer to negotiate how to negotiate how to mediate and what to do in this very situation. And the second thing, lawyers don't use it very often because usually we've got a court mediation in Poland, but this is creating an effective contract on mediation for your clients. So to precisely show the subject of the mediation and other issues, for example, confidentiality issues, not only set because the Polish law, of course, creates the confidentiality of mediation, but also other issues which might be important, and many other things. Then we've got the role of the lawyers in the shaping the process, which is selecting the mediator, okay, the proper mediator for the right case with the knowledge, experience, or maybe without the knowledge, because the knowledge might be an obstacle in mediation on the mediator's side. Then shaping the field. Who should take part in mediation? Only the lawyers with clients, the clients with support, with directors, with accountants, etc., etc. So what would be the most effective from the negotiation point of view? And then educating also the mediator and the parties. The lawyers are to educate the mediator about the case, about the perspective of the client. The director of the Leviathan Center in Poland yesterday, she told about this. The declaration statement, the declaration of statements. That's how it calls. This is one of the tools that the lawyers might use here on this very stage. Then we've got mediation in action, so negotiating, and the negotiation phase when lawyers might take a great part and negotiate the good deal for the clients. Of course, it's a huge subject, how to negotiate, how to be effective, and also to know when to withdraw from mediation. I've had mediations when the lawyers jointly decided, okay, we are stepping back. We are going to another room, let our clients talk. I also had mediations when the clients wanted to talk privately without the mediator, and that's also okay, okay? So there are a lot of options, but you have to be aware. And then constructing the settlement, of course. This is a huge responsibility on the lawyer's side. How to construct it to secure the client's interest, but also how to construct it not to fail the agreement, because sometimes those negotiations about formalities might create a very huge tension in the mediation. And then the question, which leads us to my story, to become the party of the settlement, is it possible that the lawyers will take part in the settlement, not only help the clients to construct it? And I will tell you about it. Then a short summary of the research of the lawyer's influence on mediation. And first, the question that has been asked by the Whistler was, do the lawyer's presence enhance the party's preparation to mediation? And what has been found that approximately 50% were not informed by the lawyers about the principles of mediation, how this process looks like. And the studies show that the more preparation with the client, the better lawyers' evaluation of mediation. So this has got, there are many other impacts. There are a lot of studies. These are based on the United States studies, but well, in Poland we like to say, okay, this research has been done in the United States. These are good. So I'm showing them to you now. So the second one is enhancing the fairness of the process, including reducing the pressure to settle. So the lawyers might help the clients to reduce the pressure to settle. Okay, so to say, no, you don't have to settle now. Don't feel under negotiation pressure. And the research are unclear, but rather parties perceive the process more fair with lawyers. The mediation process is more fair with the lawyers. Then activating the parties versus pacifying the parties. Do the lawyers stop clients from talking during the mediation process? And it influences, and rather it happens that, yes, indeed, the lawyers tend to stop clients from talking. Sometimes it is very good from my observation, private observation. Sometimes when, as Maria said, there are intangible matters, parties want to say something from heart, from bottom of the heart, and this is very frustrating sometimes for the parties. So you have to be very careful about this matter as lawyers, as advocates. And then effect of the level of the contentiousness, and the studies show that the less adversarial lawyer's attitude, the higher both parties and lawyers' satisfaction. Okay, so this is a very important finding. You have to, in mediation, create a cooperative attitude and show it to the other lawyer, to the clients, to be effective. Then the last one, the less settlements with lawyers, but more partial settlements. The studies in Ohio show that result. So do the lawyers facilitate or impede settlement agreement? And then the case that I told you about. Now you will have to be able to compare the general findings and what happened in the real case. The subject matter was very fragile. It was about infringement of personal interest, including sexual abuse. So you can imagine that it was a very fragile thing, right? There was a lot of emotions, a lot of regrets, etc., not only monetary, but of course money was important here. So the aspects was financial and emotional. There was also a very important influence of pre-negotiation phase on mediation. What happened here, I will tell you in a second, but first the parties negotiated, and then they went to the court, and then they went to mediation. It had a huge influence. One also situation happened, which was very bad for the parties. The lawyer of one party revealed to the court everything what happened in the negotiation before the mediation. Okay, of course, when they discussed it during the mediation, because one lawyer said, "Why did you do it?" He said, "It wasn't me, it was my client." And of course, the mediation gives you this comfort that even if the client says something in front of the court cannot consider it as evidence or anything else. So, but the negotiations, of course, in the code of ethics of the advocates, of the barristers, we've got two professions in Poland, I'm explaining to our international audience, the negotiations are confidential, but only for the lawyers. And mediation is broader in Poland. So, and then the resolution. So what happened? The claim was, of course, I've simplified the facts, I've simplified the numbers, I've anonymized the case, I've changed it a little bit so that it's still confidential. But let's imagine that the claim was 100,000 euros, okay? And then what happened? We had those negotiations before the court. And those negotiations, well, we can say it failed because the parties didn't sign a settlement or agreement, actually, that would be a settlement agreement, but the party paid 36,000 just to say, okay, I'm paying you this, but it wasn't enough, okay? But the mistake of the lawyers was they didn't conclude a settlement. They didn't finish it, okay? So they went to the court and then they went to mediation. The defendant, at the end, of course, there were a lot of meetings, there were individual meetings, also intangible matters, not only financial. If we wouldn't talk about intangible matters, it wouldn't be the contract, it wouldn't be the settlement. So these were very important, as Maria said, for the parties, and the lawyers let them talk about it. So we had, so at the end, really, it was at the edge, okay? And the defendant agreed on 50,000 to pay altogether, so to pay additionally 14,000 euros, and the claimant 60,000. So there was a 10,000 breach, and they couldn't jump it up. Defendant said, no, I will not go any further, and the claimant as well. So what to do with this additional 2,000? And can you imagine what happened on the last arrow? We've got it here. The last 10,000, which was very important, maybe from the honorable things or ambition, whatever, but it was very important for the claimant. They found a solution that the lawyer of the defendant needed services. And when they had open conversation, he or she, I don't remember, found out as a lawyer that the claimant provides such services. It was services totally out of this dispute, okay? It was like something, I don't know, delivering food, for example, or catering or whatever. And the lawyer needed those services. So they've agreed in another point of the settlement that this lawyer of the defendant will order services worth 10,000 euros from the claimant. And we had 60,000 altogether, and we had a settlement. And then after this very mediation, which I've led mediation for more than 10 years, I think, and we've had with my associate in our house of mediation yearly around 100, 200 cases, and this was one in those cases in my history. And I think everyone I'm telling this story is that it never happened. Okay, the lawyer who took part in the settlement. So this is totally. I'm finishing, Cesare. Don't you worry. So this is extraordinary. This is an exception, of course, and I'm not saying that every advocate have to involve in such a matter, but I want to show you this case to show you how far can a lawyer go to get the settlement for the client when the settlement is important. And of course, there was also a form and scope of apology, very important for the parties. They've agreed a lot of intangible things as well, but those monetary issue was solved like that. So the conclusions are: be brave and think out of the box. Use the mediator because the mediator is to help you to negotiate, to help you to find a good solution. Truly interest-based mediation, in everything is possible in interest-based mediation when you really dig into the needs, not only playing the table tennis 10-5, 10-5. No, you have to dig into the interests to find a solution. And then even the lawyer might be the part of it and rethink the role of the representation in mediation. Thank you very much. Great to be back. And Cesare will invite you for a coffee in a second. Thank you.
Great, thank you so much. So we do have a couple of minutes left for the Q&A session, just for everyone that's joining us on Zoom, just to let you know the technicality. So anytime you're speaking, I need to unmute the computer because we need to have it at 3 sources at the same time for the auditorium here at YouTube and also for you on your own computers. So right now we cannot hear you. Whenever you have anything to speak about, I'll just unmute it. And do we have any questions from the audience? Yeah, and then I'll say it to the microphone, or please come. Yep.
Okay, hello. I have a question to Mr. Ted Lim. My name is Katarzyna Bugaj-Koterba. I'm an attorney and I run my own business. I'm in my own practice. And the question is, it concerns basically those guidelines for mediators, for legal practitioners in Singapore, because as far as I'm concerned, in Poland and in all countries in Europe, no attorneys, no legal advisors, they have no guidelines. So does it actually work? Does it have any kind of impact on the outcome of the mediations? Do you think maybe there is more mediations finished with an agreement because of those guidelines? And also, if, for example, a legal practitioner, he doesn't comply, he doesn't use those guidelines, are there any consequences drawn from that conduct? To Mr. Ted Lim. Yes. I
Quickly answer backwards the repercussions of not complying with professional conduct rules. Professional conduct rules are prescribed, are kind of prescribed behavioral regulations governed by the legislation called the Legal Profession Act. The most severe penalty, I think you will find a lawyer who doesn't comply with the rules, both with the letter of the rules itself as well as the spirit of the rules, is you could be subject to a complaint by either a client or the opposing counsel or anyone else who believes that your conduct doesn't match up to what's prescribed in the professional conduct rules. And the repercussion, if a complaint is filed with the inquiry panel of the Law Society, is it goes through its stages in the disciplinary process, starting with the review committee and escalating in the most severe cases to the court of 3 judges who have the powers to disbar a lawyer. That all being said, these rules governing ADR and conduct of lawyers at ADR are fairly new in the scheme of conduct rules for lawyers. You asked a good question as to whether they have the effect, as I understand, of shifting behavior. The very fact that I give you that example when I started my talk shows that I think these kinds of behavior takes time to shift. But also, I don't think it's a zero-sum game. I think lawyers do try their best to work the client's best interest into their conduct of a case. It's just that there are 2 paradigms, and I mean, all of us who are in practice understand. The practice paradigm of finding your client's best case theory and prosecuting in an adversarial process is not, it's very different kind of landscape compared to the collaborative process in mediation. The difficulty is how do you mesh the 2 and weave it so that you are able to continue with the litigation process, but yet not damage your client's prospect in moving towards a mediation process. And that, I think, is a tension always that lawyers face. How do you be a good, confident, effective litigation lawyer and yet not be a ineffective mediation counsel? But again, those rules, I think, will have an effect as you move forward. In fact, it's all in Singapore, it's very much driven by the judiciary and the Ministry of Law. So with all that support, I think you will find that, like, I think what Eleanor and some of the other speakers are saying, lawyers' mindset tends to be very dogmatic, and it takes a lot of effort to shift. But in Singapore, because we have had that history of many years where the pressures have come from many different quarters, the mindset has shifted. And to the extent now, I think it's a given that if you behave in a particular way, you might find yourself in trouble. So the short answer is, I think those rules and professional conduct guidelines has an effect, but they do take time to change mindsets and practice. Back to you, Cesare.
From the audience. We have just one comment from YouTube that I'll just put it here because it's multi-channel really. So it was from Professor Agnieszka Lewicka-Zelen that we heard yesterday, that in her opinion it's a very good practice to have a permanent sorry, but that's in Polish, so I'm translating that on the spot. A permanent education for mediators for at least 20 hours for every 5 years. The knowledge needs to be updated and the skills need to be brought to the higher level. And it's also important in terms of the legislative changes and the projected amendments that we might be facing. So I'm putting that and whenever. Do you have anything to add? Do you have any comments for the end of the panel? And that I'm also looking, because Lino had to leave us for another meeting. Thank you once more, Lino, for being with us. And Elena or Tad, do you have anything else to add? So for the end of our panel, because then.
Okay, thank you, Cesare. I want to add to the need for education. And of course, time was limited. I wanted to share more developments, but it seems that our Ministry of Justice has secured a funded project that will aim of some million of euros that will aim to the education on mediation advocacy to all lawyers in Greece. So it's going to be subsidized by European money, so that we can educate all lawyers, probably starting from September this year. It was, again, due to COVID that we were left a little bit behind, because we realized that that is a very important stakeholder. And Tad raised two very nice questions. So, should we be looking for to mediation without lawyers? Or is that an option? I would say we should be looking at educating also lawyers as well as mediators to the new challenges. Thank you very much again for having this.
We need to finish now because I'm sorry, I need to mute it right now. Now it's working. So we need to finish now. So we'll move our discussion also to the coffee break. Thank you so much, Elena and Tad, for joining us on online, and we hope for next time we'll be all in the same room and we'll meet and thank you very, very much for your thoughtful presentations. Hope to see you soon and have a great weekend now. Right. Yeah, thank you. Goodbye. Bardzo dziękuję i również zapraszam na przerwę kawową, troszeczkę krótszą niż przewidywana, żebyśmy mogli wszystko zakończyć o czasie. Dziękuję bardzo.